Good afternoon, everyone. This is Kristen O'Neill with the Committee on Open Government. Thank you for joining me today for our program on the New York State Open Meetings Law. Just do some housekeeping for a second. For those of you that were scheduled to do the program with me last week, again, apologies. As you might know, my voice isn't still 100%, so if you hear me pausing at certain points, it's probably to take a sip of water or possibly even to mute you to blow my nose. I apologize if that's too much information, but I just want to give you a heads up that I'm not like 100%, just the voice. It's taken a little bit longer to recover. So today we're going to go over the basics of the open meetings law, but also focus a little bit on some of the updates that have the amendments to the statute that have occurred in the past couple of years, particularly relating to video conferencing. Before we get to that point, I'm going to stop sharing this PowerPoint for just a second and show you the, excuse me, I'm going to pull up committee's website just to give you a very quick overview. This is our website, the Committee on Open Government's website. It's opengovernment.ny.gov. Lots of good information you can find on our site. We have at the top of on the menu bars, we have copies of the text, our regulations, advisory opinions that are indexed alphabetically by key phrase, case law summaries. Same goes for the open meetings law. We'll have notification of any minute meetings of the Committee on Open Government. Information about that will be here. We have a little bit of an About Us page, including information about our executive director and our committee members. Of course, we have a Contact Us page. And anything, any significant amendment to either the Freedom of Information Law or the Open Meetings Law, this is probably where you're going to find a notification of it. If you've heard rumblings about changes to the law, come take a look at our homepage, and hopefully we should have some information there on our homepage that will help you out. And of course, you're always welcome to contact us directly if you do have questions. If you scroll down our page a little bit, you'll find that we have some little helpful sections if you're looking for sample language for making a FOIL request, appealing a FOIL denial. A lot of this does have to do with FOIL, but that tends to be more of a written, excuse me, a written process. So we provide that guidance language. We have, if you are an organization that a municipality or a government group, anything of that nature, and you'd like to request training for your organization, this is how you go about submitting a request, and you'll probably end up reaching out to me through this request training button. We have recordings of our committee meetings, and we have recordings of our my training programs. So if you go to this page, you'll see this button will bring you to our YouTube page that has recordings of our programs. And here is our PDF copies of the PowerPoints that I use for my programs. I just submitted a request today to have the most up-to-date versions of my PowerPoints or PDF copies of my PowerPoints available through these links. I'm not sure that it's occurred yet. Sometime in the next day or so, these should bring you to the most up-to-date versions of my training programs. So I just wanted to share that with you to our poem. Up on the screen, you'll see my name, my title, the telephone number for our office. So 518-474-2518. If you call that number, sometimes you may need to leave a message only because we're a small office and there are times when that our phones will get a little bit busy. So if you do have to leave a message, don't worry too much. We do make every attempt to return phone calls either the same business days, or sometimes if it's a little bit later in the day, it may be the next business day, but we really try to return phone calls as quickly as possible. Again, there's our website, opengovernment.ny.gov, and our joint email account. So it's COOG, which is our acronym for Committee on Open Government, at dos.ny.gov. So if you have a question, if you email that address, any of the attorneys in our office can get back to you as quickly as possible. The Open Meetings Law is codified in Public Officers Law, Article 7, Sections 100 through 111. Our website, as I mentioned, we always try to keep the version that's on our website accurate and up to date, so that's one easy way to locate a copy of the statute. When the law was passed in 1976, the legislature reflected the intent as it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. The legislative intent goes on to say that citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So the Open Meetings Law applies to all aspects of the decision-making process, not just the final votes. Open Meetings Law governs conduct of meetings of public bodies. And the term has a very lengthy and a bit convoluted definition. What I'll do is sort of, instead of reading through the language, I'm going to try to break down the aspects that are important in determining whether an entity is a public body subject to the Open Meetings Law. I note at the bottom of this page that the underlined portions reflect language that was amended in the past couple of years. So the first thing you looked at is whether the entity is requires a quorum in order to conduct public business. And oftentimes the statute that creates a public body doesn't specifically mention quorum. But what you want to think about is whether the entity only has legal authority collectively as a body. Sometimes you have meetings where each individual attending the meeting has his or her own individual authority. Public bodies only have legal authority when they act collectively as a body. And a quorum is required because in order for any public body to take action, you need to have a majority of the total membership approving any action. So that's where the reference to quorum comes in. It refers to entities that only act collectively as a body. These public bodies must consist of 2 or more members performing a governmental function for the state or an agency or department thereof, or for municipalities such as counties, cities, towns, villages, school boards, etc. So you have entities that we're all quite familiar with, such as the New York State Legislature, county legislators, county boards of supervisors, city councils, town boards, village boards, library boards of trustees, school boards. All those entities are public bodies subject to the Open Meetings Law. The law goes on to state that any committee or subcommittee or other similar body consisting of members of the public body is also a public body subject to the Open Meetings Law. So the easiest way to explain this is through use of an example. Say you have a 9-member school board, and the 9-member school board has designated 3 individuals to act as their finance committee. That finance committee then becomes its own public body, as 3 of the members of the school board have been designated to serve on this committee. So now the finance committee is also a public body that every meeting of that finance committee must be held in compliance with the Open Meetings Law. The definition goes on to talk about an entity that is created or appointed to perform a necessary function in the decision-making process and consists of 2 or more members. This amendment was intended to address the type of public body that isn't necessarily a governing body of a municipality like town boards and village boards, uh, but they do serve a statutory function. For example, at the state level, there are numerous entities, public bodies that aren't governing bodies. They aren't in charge of the agency. They can't make final decisions for an entire agency or municipality. But by New York State statute, they have been designated to serve an essential function in the decision-making process for state government. For example, I mean, the Committee on Open Government, although to a large extent advisory, is a public body subject to the open meetings law. Because we are created by New York State statute, there are certain things that we are required by statute to do every year. We have the authority to create regulations. We are required to prepare a report to the governor and the legislature, and we have functions that we are required to perform on a day-to-day basis. So even though we aren't a governing body, we are a public body, and because we serve a necessary function in the decision-making process of government. The law then goes on to clarify again, a necessary function in the decision-making process shall not include the provision of recommendations which are purely advisory and do not require further action by the governing body or the head of an agency. So, for example, if you have an entity that is 100% purely advisory in nature and is not made up entirely of members of a full public body, that advisory body is likely not going to be considered by the courts to be a public body subject to the open meetings law. So these are the questions that we ask. Have two or more people been given the authority to act collectively? Is a quorum necessary to conduct public business? Is it a committee made up solely or primarily of members of the larger public body? Does the committee serve a state statutory function? Does the body serve a state statutory function? Is that function more than merely providing advice? The alternative, if the entity is purely advisory in nature with no statutory duties or final decision-making authority, then the answer is probably no, not a public body. The term quorum is defined in general construction law. And it states that whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly or as a board or similar body, a majority of the whole number gathered together in the presence of each other or through the use of video conferencing shall constitute a quorum. And not less than a majority of the whole number may perform and exercise such power, authority, or duty. So if you have a 9-member board and only 4 people show up to the meeting, 4 members of your body show up to the meeting, you might as well just go home, because 4 members of a public body have no authority to take action. They have no authority to act as a body because they haven't met that quorum requirement yet. The definition clarifies that for the purposes of the provision of the words whole number shall be construed to mean the total number which the body would have if there were no vacancies and none of the persons or officers were disqualified from acting. So if you have the Committee on Open Government, for example, is a little bit short-staffed right now. The law requires that we have 11 members. Right now, I believe we have 9 members right now, that we have some vacancies. But when determining a quorum, it doesn't matter whether we have vacancies or not. A quorum for the Committee on Open Government will always, always, always be 6, regardless of how many people show up to the meeting and regardless of how many people are currently appointed to the committee. Because this law says we're a public body made up of 11 individuals, then quorum is always going to be 6. In April of last year, Governor Hochul signed Chapter 56 of the Laws of 22. It was part of the New York State budget. Included in the bill is an amendment to the open meetings law to expand the use of video conferencing by public bodies to conduct open meetings under extraordinary circumstances, regardless of a declaration of emergency. This provision will be in effect until July 1st, 2024, unless extended by the legislature. The new provision is not meant to change or curtail what has always been permitted for or required of public bodies in relation to compliance with the open meetings law. Public bodies may continue to operate now as they did before the onset of the pandemic in early 2020, when the in-person aspects of the open meetings law were first suspended. If a public body was permitted to do it before the pandemic, this law does not change that. The law is intended to only expand, in extraordinary circumstances only, the ability of public bodies to meet using remote access technology. Once Chapter 56 was passed last year, it created a second way to use video conferencing technology to conduct open meetings. The law for many years had already contained a mechanism for the use of video conferencing to conduct open meetings. The first way that has existed for several years now, pre-pandemic, was by connecting multiple physical locations that are open to in-person public attendance. Again, using our own committee as an example, we're an 11-member body with appointees that live all over the state. So when we have our meetings, we use Department of State offices. We open up a site in Buffalo, in Albany, and in New York City, and let our members know that they can choose which site that they would like to attend from. And then we notify the public which sites will be open, which sites from which members will be attending. That information is included in the meeting notice. So the physical locations at Buffalo, Albany, and New York City will be open to in-person public attendance. And then all of those locations are connected through the use of video conferencing, where we'll have large screen TVs, and we can hear and see all of the members in all the different conference rooms, all connected through the use of video conferencing. But the important factor with the pre-pandemic #1 rule is that all of those locations where the members are attending from are open to the public. The second mechanism, the second way of using video conferencing technology, is the one that was established through Chapter 56. And that's where a member can be allowed to participate from a private location through video conferencing, but only under extraordinary circumstances. The public bodies using the first type of video conferencing, where you're connecting multiple physical locations that are open to the public, the new provisions of the open meetings law do not apply. The new Section 103A does not apply to the way of the video conferencing that existed pre-pandemic. Chapter 56 says that a public body may, in its discretion, use video conferencing, conduct its meetings pursuant to the requirements of this article, provided that a minimum number of members are present to fulfill the public body's quorum requirements in the same physical location or locations where the public can attend, and the following criteria are met. What this means is that in order to allow any one of your members to attend, excuse me, my voice is going, attend using extraordinary circumstances video conferencing, you must first have a quorum at an open public location. Sure, you can't allow all of your members to attend using extraordinary circumstances video conferencing, because then you wouldn't have a quorum at an open public location. In the most recent, most recent budget, New York State budget that was passed, Chapter 58 of the laws of 2023, the open meetings law was essentially amended to allow a public body to establish written procedures that would allow a member who has a disability, as defined in New York State executive law, where the disability renders such member unable to participate in person at any such meeting location where the public can attend, to be considered present for purposes of fulfilling the quorum requirements. So this is the exception. Generally, if an individual is attending from a private location under extraordinary circumstances, they do not count towards a quorum. This amendment creates a carve-out for individuals with disabilities as defined by New York State law, and where that disability renders them unable to participate in person at a public location, they can be counted towards the quorum. But the governing body, the public body has to establish written procedures. So quick summary, members who are participating from a physical location that has been properly noticed and is open to in-person public attendance do count towards a quorum and may fully participate and vote. Members who are video conferencing from a remote location that is not open to in-person public attendance do not count towards a quorum unless they meet the disability criteria. Those members may, however, fully participate and vote if a quorum has otherwise been met. Chapter 56 requires that in order to allow its members to use extraordinary circumstances video conferencing, governing bodies of counties, cities, towns, and villages must first adopt a local law, and the Senate and the Assembly had to adopt a joint resolution, and all other public bodies must adopt a resolution following a public hearing. All public bodies, governing bodies, and all other public bodies had to have a public hearing prior to passing a resolution authorizing the use of video conferencing. A governing body could pass a resolution for itself and all of its committees or subcommittees that are housed within that agency, within that municipality, or they can specify that each committee or subcommittee can make its own determination. The law clarifies that every New York City community board can make its own determination with regard to extraordinary circumstances video conferencing. So here, for an example, we've offered the opinion that if you have a city council, the city council could pass a local law that covers not just the city council, but any public body that is housed by the city. So if you have, for example, planning boards and ZBAs and finance committees, health committees, whatever the case may be, any public body that is housed by the agency, the governing body of that agency can pass one single resolution, or they can pass a resolution just for themselves and leave it up to everyone else to make their own decisions. Public body must establish written procedures governing member and public attendance consistent with this section, and the written procedures have to be conspicuously posted on the public website of the public body. This is just another section that talks about quorum. To some extent, it states that members of the public body must be physically present at any meeting unless the member is unable to be physically present due to extraordinary circumstances. The open meetings law includes examples of what the legislature intended to include under extraordinary circumstances: disability, illness, caregiving responsibilities, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. Except for executive sessions, the public body must ensure that members of the public body can be heard, seen, and identified while the meeting is being conducted, including but not limited to any motions, proposals, resolutions, and any other matter formally discussed or voted upon. The shorthand for this is cameras on. During the pandemic, when the executive orders were in place, and when Chapter 417 and Chapter 1 were in place, authorizing the use of remote access technology during the pandemic, we would hear from the public that there was a significant amount of individuals who are serving on public bodies that would sign on to a WebEx or a Zoom, but they would turn their cameras off. And because the executive orders and the temporary laws that authorized the use of remote access technology didn't specifically require the use of video, they were allowed to have their cameras off. But here, the law is specific and says, no, everybody who serves on the public has to be heard, seen, and identified while the meeting's being conducted. The identified portion means if you're logging onto, for example, a Zoom or a WebEx, the person should be typing their full name into the box. It shouldn't just say a phone number or an email address. It should have the person's full name appearing on the screen. It also means, because they're not limiting it just to those individuals serving, they're attending via video conference, that all the individuals actually on the public body must be able to be identified, like through a name placard or something. The minutes of every meeting involving extraordinary circumstances video conferencing must include which, if any, members participated remotely, and must be available to the public pursuant to Section 106 of the Open Meetings Law, just as has always been required. This is just an addition to the requirement for what must be included in meeting minutes. If the extraordinary circumstances video conferencing is used to conduct a meeting, the public notice for the meeting shall inform the public that video conferencing will be used. The notice must state where the public can view and or participate in the meeting, where required documents records will be posted, and identify the physical location for the meeting where the public can attend. So when a public body allows one of its members to attend via remote access technology, via video conferencing specifically, it must also allow the public to attend via video conferencing. So once you allow one of your members to attend from a private location using extraordinary circumstances video conferencing, that video conferencing must then be open to everyone. They have to provide a link or something where the public can also view and participate in the meetings remotely. The law requires that if you're using extraordinary circumstances video conferencing, the meeting must be recorded and the recording must be posted or linked on the public website within 5 business days following the meeting and must remain available for a minimum of 5 years thereafter. The recordings must be transcribed upon request. Extraordinary circumstances video conferencing is used to conduct a meeting. The public body shall provide the opportunity for members of the public to view the meeting via video and to participate in proceedings via video conferencing in real time where public comment or participation is authorized, and ensure that video conferencing authorizes the same public participation or testimony as in-person participation or testimony. So this is a distinction between the pandemic version of video conferencing as well. During the pandemic, there was really nothing in the governor's executive orders or the temporary legislation that required public bodies that were allowing their members to attend via remote access to afford the public who was attending via remote access an opportunity to engage in public comment. So even if the people who were showing up in person were allowed to take advantage of the public body's public comment period, they didn't have to allow the members that were attending via WebEx or Zoom to do the same. So this is an important change. If you allow your member to attend via remote, excuse me, my voice is really going, I apologize. If you have a member that is attending via extraordinary circumstances video conferencing, you have to establish that video conferencing connection for the public. And if you're allowing members of the public to speak during the meeting, if they show up in person, you also have to allow them to speak during the meeting when they show up via video conferencing. Whatever rule you establish for in-person public comment must also apply to the individuals that are attending via video conferencing. Because there are certain obligations that are created under this new provision for what you must post on websites, the law clarifies that any local public body electing to utilize video conferencing must maintain an official website. The law includes a provision relating to possible future state disaster emergencies, either declared by the governor or local states of emergency proclaimed by the chief executive of a county, city, village, or town. If the public body determines that the circumstances necessitating the emergency declaration would affect or impair the ability of a public body to hold an in-person meeting, they can suspend the in-person requirements. I think essentially, although it's not 100% clear from the language, my understanding of this is if there is a state declared disaster emergency or a local state of emergency, which would impair the ability of a public body to have an in-person meeting, then they can essentially go back to what we used to do during the pandemic, is provide a fully remote meeting. That is my understanding of this provision. But please keep in mind that it's not just that there has to be a state of emergency. The state of emergency has to impair the ability of the public body to hold an in-person meeting. So the fact that there was a declared disaster emergency relating to polio and monkeypox is not affecting or impairing the ability of public bodies to hold in-person meetings. So a public body cannot rely on the governor's monkeypox and polio declared disaster emergencies to revert to fully remote meetings. No later than January 1st, 2024, the Committee on Open Government is required to issue a report to the governor and the legislature concerning the application and implementation of this amendment, and make any further recommendations governing the use of video conferencing to the governor and the legislature. Here I'm going to make a pitch. This summer, we have a college intern coming on board, hopefully pretty soon. And what we would like this college intern to do is start reaching out to individuals and groups and municipalities to see if they're willing to just take a few minutes to give feedback regarding these new Chapter 56 provisions. And we would never take up too much of anyone's time, but if people are willing to set aside 5 to 10 minutes to give us their feedback about how this is working, or any suggestions or recommendations for improvement, we would greatly appreciate that. If you proactively would like us to reach out to you, you can email me directly. You can title the email video conferencing survey. You can either email myself or the Coug inbox and just include a note saying that you would like to be included in the survey. It would be very much appreciated to anyone who is willing to participate, because the more feedback we can get from not just the government agencies, but perhaps the media or the public in general, people that are willing to provide feedback on how it's working, it would be greatly appreciated. So again, if anyone's willing to proactively volunteer for this survey, please just either email myself or the Coug at dos.ny.gov. You can title the email video conferencing survey and indicate that you're willing to participate. That would be very much appreciated. The law requires that any meeting using the extraordinary video conferencing must use technology to permit access by members of the public with disabilities consistent with the 1990 Americans with Disabilities Act. We've gotten some questions about what this means, and the Committee on Open Government, we are not attorneys that have significant amount of knowledge, or it's not sort of our area. Expertise is not the right word, but our area of research or practice, disabilities law. So I would recommend consulting. If you're a governing body and you have concerns, do consult with your own municipal attorneys. for guidance regarding this issue, because the Committee on Open Government really only has the authority to provide legal advice regarding the open government statutes, and we feel that it would be overstepping our boundaries to provide legal advice regarding the ADA compliance. Notice. Every meeting of a public body, notice must be given. Notice must include the date, time, and location, and if appropriate, instructions for virtual attendance. The notice must be given prior to every meeting to the media. Doesn't mean that a public body needs to purchase a legal notice, just that the media must be provided notice of the meeting. Must be placed in a designated physical location. And if the agency or public body has an active website, it should be posted on the website. Notice must be given at least 72 hours prior to a meeting that was scheduled at least 1 week in advance. For meetings on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. The law is silent as to when a public body is permitted to have meetings on short notice, but the courts have weighed in, and the courts have suggested that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. So if there would, if some harm would be caused by waiting, certainly a public body can go ahead and have the meeting on the short notice. But if there's actually no need to have a meeting on short notice, the courts would probably frown on a public body doing so. If extraordinary circumstances video conferencing is used, public notice must inform the public that it will be used and where the public can view or participate in the meeting. Records scheduled to be discussed at an open meeting. In October of 2021, Governor Hochul signed into law Chapter 481, which amended Section 103 of the Open Meetings Law to require that records to be discussed at an open meeting must be made available to the extent practicable upon request, must be posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. So the obligation to make records available to the public upon request prior to or at the meeting has been in effect since February 2012. This amendment simply places a 24-hour minimum time frame for making those records available. So what does this include? It includes any proposed resolutions, laws, rules, regulations, policies, or any amendment to any of those things. And it also includes any records or portions of records that are public under FOIL that are scheduled to be discussed during an open session. This does not apply to records scheduled to be discussed in an executive session. Minutes. Minutes of a meeting of a public body must include all motions, proposals, resolutions, and any matter formally voted upon and the votes thereon. Extraordinary circumstances video conferencing is used must include which, if any, members participated remotely. A public body only needs to prepare minutes of an executive session if action is taken in executive session. If a public body goes into executive session, deliberates, and then exits executive session prior to voting, it would not be required to prepare separate minutes of the executive session. However, if it does go into executive session and deliberate and vote, the public must prepare minutes of that executive session. Those minutes must be available within 2 weeks for an open session and 1 week for an executive session. It doesn't matter whether the minutes are unapproved or in draft form. If someone asks for them, they must be provided. In November of 2021, Governor Hochul signed into law Chapter 587, which amends the Open Meetings Law to require agencies that maintain a website and use a high-speed internet connection to post meeting minutes on its website within 2 weeks of the date of the meeting or within 1 week of an executive session. The law states that for purposes of this subdivision, so to clarify, this is not alleviating anyone's obligation to prepare minutes. It's just relating to posting. So purposes of this subdivision, unabridged video recordings or unabridged audio recordings or unabridged written transcripts may be deemed to be meeting minutes. So Public body must still prepare minutes within 2 weeks of an open session and 1 week of an executive session. But if instead of posting those minutes within 2 weeks, it would prefer to post an unabridged video or audio recording or an unabridged transcript, it can do that. But that's the transcript and the recording is only helping the public body out with the posting requirement. The minutes must still be prepared. Recording. Any meeting of a public body that's open to the public must be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means. Agency itself, the public body itself, is not obligated to record unless a member is participating remotely as authorized under Section 103A. An agency can establish reasonable rules to limit disruption or interference, and we have model rules that a public body or an agency can model theirs on, available on our website. Executive session. Executive session is defined in Section 102(3) of the law as a portion of an open meeting that is not open to the public. An executive session should never be prior to or separate from an open meeting. It must be a portion of an open meeting that occurs after the open meeting has started. In order to enter into executive session, a motion must be made in open session and voted upon during open session. The motion to enter into executive session must be specific enough to reflect to fellow board members and to the public that the board is entering into executive session for a proper purpose. It does not need to be so specific that it defeats the purpose of the executive session. In just a little bit, I'll give you an example. Here up on the screen right now, you'll see the grounds for entering into executive session. An executive session can only occur to discuss these topics. If you don't see it on this list, it's not an appropriate conversation for executive session. For example, we unfortunately quite frequently, see minutes or agendas where a public body reflects an intent or that it or has already occurred that they're discussing contract negotiations in executive session. There's nothing on here about contract negotiations generally. The only provision relating to negotiations has to do with collective bargaining negotiations under the Taylor Law. Contract negotiations is not permissible ground for entering into executive session. Discussions regarding proposed pending or current litigation. There, you want to keep in mind that this says proposed pending or current litigation. It does not say possible or prospective litigation. Every discussion a public body has the potential to lead to litigation. Every decision a public body makes has the potential to lead to litigation. But what this executive session provision only allows a public body to discuss actual proposed pending or current litigation, and the purpose is to allow the public body to discuss litigation strategy that has been clearly set forth in case law. One of the grounds that we see quite frequently asserted for entering into executive session, people use the word personnel. If you read through the open meetings law, you will never see the word personnel. What the law does state is that a public body can enter into executive session to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. Mentioned a few seconds ago that I would give you an example of a motion to enter into executive session that is specific enough to reflect that the body's going in for a proper purpose, but not so specific that it's defeating the purpose of the session. So for example, perhaps you have allegations of employee misconduct have been brought to the attention of a governing body. And the governing body needs to discuss these allegations to determine whether they want to initiate an investigation or perhaps whether there's sufficient information to either discipline or suspend or remove a particular person. So an appropriate motion may be is that the public body is moving to enter into executive session to discuss the employment history of a particular person and matters that may lead to the discipline, suspension, or dismissal of a particular person. The motion does not need to identify the employee whose employment history is being reviewed, but it should be specific enough. You shouldn't be just reciting the language of the statute. The motion should pick the parts of the statute that apply. The second avenue for meeting behind closed doors for a public body is if there's an exemption. Section 108 of the Open Meetings Law allows certain topics to be exempt from the Open Meetings Law. If the exemption applies, the Open Meetings Law does not apply. It's as if the Open Meetings Law does not exist, and there are 3 exemptions. One are judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and the zoning boards of appeals. 2 are deliberations of political committees, conferences, and caucuses. What this means is if you have a 5-member town board, 3 members are Democrats, 2 members are Republicans, those 3 Democrats are permitted to meet and discuss whatever they want, whenever they want, without notifying the public, without inviting the public to attend, even though they represent a quorum of the public body, because they are a political committee of Democrats of the town board, they are permitted to meet and discuss whatever they want. Of course, they can't vote. They don't have no authority to take action at these political committee meetings, but they can meet and discuss whatever they want. The third exemption is any matter made confidential by federal or state law. One example, for school boards is any discussions relating to students that are made, or that discussion would be confidential under the Family Educational Rights and Privacy Act. And a very common example is meetings with an agency attorney that are covered by the attorney-client privilege. So this means for example, if a town board wants to meet with their town attorney for the sole purpose of requesting and receiving legal advice, that meeting would be exempt from the Open Meetings Law. But it's only exempt to the extent that the attorney is playing an active role in the conversation by providing legal advice. Once the attorney ceases to be playing that active role of having a conversation that's covered by the attorney-client privilege, the exemption ends. So any further conversation by the public body would need to occur within the confines of an open meeting. Non-compliance, the Committee on Open Government does not have enforcement authority. We provide advice, opinions, training, guidance, but we do not have enforcement authority. We do not investigate complaints. We do not issue counseling memos. I call them slap on the wrist letters. That's not our role. We're not disciplinarians. We provide advice. Enforcement is through the initiation of a Civil Practice Law and Rules Article 78 proceeding. The court, if a petitioner substantially prevails, the court has the authority to award costs and attorney's fees, could possibly invalidate actions or require training from the Committee on Open Government. The court's only going to generally invalidate an action taken when the petitioner not only just substantially prevails in the proceeding, but where the court finds that the violation was substantial and not merely technical. If the court finds that it was a merely technical violation, they likely are not going to invalidate the actions taken. Anyone's welcome to contact our office by phone or by email with questions, whether you're a government employee, members of the public, media, representatives, etc. Our phone number is 518-474-2518. Our email address is coog@dos.ny.gov. As a reminder to everyone who may have missed the first part of the program, I showed everyone where they can find these training materials. They're available on our website under the section called Training Recordings and Materials, Training Materials and Recordings. Within the next couple of days, perhaps early next week, I will have a recording of this program available on our YouTube page, which is linked from our homepage. And again, I'm not sure if it may already be there, but a PDF copy of this PowerPoint, if not already there, should be there within the next, I think, 24 hours. But there's a slightly dated version that's on there now. But I asked for an up-to-date version to be posted today, so hopefully that'll get done in the next 24 hours. So for anyone that maybe missed the beginning program and was wondering whether the materials and the recordings will be available, yes, they will be. We can take a little time. I know you guys are probably all sick of hearing my raspy voice, but I can take a little time to go to see if there's any questions in the chat. One of the questions was about the PowerPoint so let me just skim through and see if there's anything else. At this moment, I don't have other questions in the chat feature. If you do have questions, you are more than welcome to either email me directly. If you have a question specifically about excuse me, if you have specifically about the program, about this presentation, certainly go ahead and email me directly. If you just have a question generally about the open meetings law or freedom of information law down the road, you can email the Coog account. Someone asked how long recordings have to be left up. If it's a recording of a meeting that's required pursuant to the extraordinary circumstances provision, the law requires that the recordings of meetings stay up for 5 years. Someone else has asked, I'm trying to make this bigger so it's easier to read. Someone asked me about whether Section 103A applies if three locations are joined by members present via video conferencing. So as one of the slides on the PowerPoint states, is that if you're using the old pre-pandemic way of video conferencing, where the members are all participating from open locations, like, for example, the Committee on Open Government has their location in Buffalo, Albany, and New York City. All three of those locations are open to the public and they are connected through the use of video conferencing. Then the new requirements of Section 103A do not apply to that older way of using video conferencing. 103A only applies to situations in which a member is participating from a private location under extraordinary circumstances. So thank you everybody for joining me today. Thank you for being patient with my voice and my stuffy nose. I promise you, it was much worse last week. I could barely get 2 words out without coughing up a lung. So at least you had me today and not last week. And I hope everyone has a lovely day. Thank you so much.